Hi, thank you and welcome back to my channel. So women's rights have been a hot topic lately, especially since Roe v. Wade was overturned. But right now I am going to shock you. I am going to take you down the journey of women's rights from 1923 to today. You're guaranteed to be shocked by at least one of these. Guaranteed. I don't know what you're going to get if I don't promise, if my promise doesn't come through for you, but okay, here we go. 1923. 1923 is the year the Equal Rights Amendment was introduced to Congress. So, what the Equal Rights Amendment was supposed to do was to give women the same rights men have under the Constitution in terms of property, employment, and education. It was sent for ratification in 1972, which is a fancy way of saying it was sent for signature. The bill did not pass. And then 4 years later, in 1976, the Supreme Court declared that women were covered by the Equal Protection Clause of the 14th Amendment. And ultimately, any distinctions between sex have to be backed by an important state interest. So that bill basically just died, but then the Supreme Court took care of it in 1976. Okay, here we go. 1938, the year of the Fair Labor Standards Act. Fair Labor Standards Act establishes minimum wage without regard to sex. I mean, that's really nice that that was put into place today, but we still know that there's a huge discrepancy in how much women are paid compared to their male counterparts, but at least there was good intention there. 1947. Okay, so a lot of women are not going to love this, but this is the year where the Supreme Court ordered that women are equally qualified with men to serve on juries. So I'm just going to skip past this one because I know a lot of people hate jury duty. Okay, so we're passing over the 50s. Nothing really happened then. Women were just in the house. Okay, so 1963, the Equal Pay Act is passed by Congress. So this act promised equitable wages for the same work, regardless of race, color, religion, national origin, and sex. We still know this is a big issue, but we have an act. Okay, so now we're getting into the juicy, fun, creepy stuff. Okay, so the year is 1965. The Supreme Court rules on Griswold v. Connecticut. What did they rule on? They actually overturned one of the last state laws, which prohibited the prescription or use of contraceptives by married couples. So prior to 1965, if you were a married woman in Connecticut, you're prohibited from having birth control. Okay, now we are going to 1968. 1968, Executive Order 11246 was passed. I'm never going to remember that number, but it prohibits sex discrimination by government contractors and requires affirmative action plans for hiring women. And you're probably like, what's affirmative action? Affirmative action is actually considered or sometimes called positive discrimination. So it involves a set of policies and practices within a government or an organization seeking to include groups based on gender, race, sexuality, creed, or nationality in areas when they're typically passed over or underrepresented, such as education and employment. So historically, affirmative action has supported these groups of people in achieving goals such as bridging inequalities in employment and pay, increasing action to education, promoting diversity, and readdressing apparent past wrongs, harms, or hindrances. Okay, here we are, 1971. The Supreme Court allows the practice of private employers refusing to hire a woman with preschool age children. So before 1971, if you were a business owner and you were interviewing people and you interview a woman and she has a preschool child, it was totally fine for you to reject her application because you didn't want that little baby in the office. After 71, nope, sorry, can't discriminate. You can't discriminate against preschool women who have preschool children. Very important for single ladies, 1972. That is when the Supreme Court ruled on Einstead v. Baird. Drum roll. No, my desk is shaking. Okay. The Supreme Court rules that the right to privacy in the Constitution also encompasses an unmarried person's right to contraceptives. So prior to 1972, if you were a single woman, there was no right for contraceptives. Glad that changed. 1973 was a busy year for the Supreme Court. So, the first case, the US Supreme Court banned sex segregated help wanted advertising as a violation of Title VII of the Civil Rights Act of 1964. So, no help wanted ads specifically asking for men, specifically asking for women. Nope, nope, nope. Can't do that anymore. Okay, this one has been overturned as of super recently, 1973. Roe v. Wade, protecting a person's right to terminate an early pregnancy. That was recently overturned in 2022. Thanks, Supreme Court. Okay, next one, which was very juicy and interesting. So the year is 1973. You're a working woman, working, doing whatever you want. You're really good with your money, unlike me. Saving your money, you want to make a big purchase. Maybe you want to purchase a pony. Maybe you want to purchase a house. You have a lot of money, but you don't have all of the money. So you think, oh, maybe I'll get credit. Maybe I'll get a mortgage for the house, credit card for the pony. You're going to have a very, very, very hard time. Okay, so in 1974, Congress declared that housing discrimination on the basis of sex and credit discrimination against women were outlawed. And then shortly after, in 1974, the same year, the Equal Credit Opportunity Act passed, which was supposed to prohibit credit discrimination on the basis of gender. But before then, many banks granted credit cards to women only if they had their husband's signature and outright refused them to unmarried women. And how many husbands are going to let a woman buy a pony on credit? Not the fun ones, at least. But as a woman, think about the implications of the Equal Credit Opportunity Act and think about divorce rates now. Everyone was married. Everyone thinks, oh, everyone was married happy then, and divorce has skyrocketed within the past few decades. But think about how many women stayed in marriages that were maybe not the best for them because they had trouble getting housing and credit. So the Equal Credit Opportunity Act was a super, super liberating act for women, and this was a real milestone in giving women our freedom. Okay, so there is one instance that I found. It's not federal, it's specifically related to a state, but there is at least one instance of women getting to do something men could not. So prior to 1976, in Oklahoma, there was a state law that ruled that women between the ages of 18 and 20 were allowed to drink beer while men of the same age were not. So, I mean, that was something. Now men have equal rights than us. So. Okay, here we are, 1978. The Pregnancy Discrimination Act came into play, and that bans employment discrimination against pregnant women. Okay, here we go, 1998. So another employment-related ruling. So employers are liable for sexual harassment even in instances when a supervisor's threats are not carried out. Duh. If someone says something gross to you and they don't do it, the employer should still be responsible, right? Well, there's an exception. Not necessarily an exception, but a nuance. The employer can defend himself by stating that it took steps to prevent or promptly correct any sexually harassing behavior, and also show that the employee didn't take advantage of any available opportunities to stop the behavior or complain about the behavior. Here we go. We're in the 2000s. Wow, not much happened from 1988 to 2009. That was 9 years. Dang. Okay. Anyway, so in 2009, the Lilly Ledbetter Fair Pay Restoration Act came into play, which allows victims, who are usually women, of pay discrimination to file a complaint with the government against their employer within 100 days of their last paycheck. Okay, the year 2010, the controversial Obamacare, or the Affordable Health Care Act, came into play. Signed into law. Under this act, Private health insurance companies must provide birth control without copays or deductibles. The law also requires private insurance companies to cover preventative services. 2013, for the military ladies. So in 2013, the ban against women in military combat positions is removed. This overturned a 1994 Pentagon decision restricting women from combat roles. Interesting. Okay, 2013, that's the reauthorization of the Violence Against Women's Act. This new bill extends coverage to women of Native American tribal lands who are attacked by non-tribal residents, as well as lesbians and immigrants. There you go. I've taken you through 100 years of the evolution of women's rights in the US. If you weren't surprised about any of them, please leave a comment. Or, I mean, if you knew them all already and I didn't shock you at all, please leave a comment. And if you like this, make sure to like and subscribe.